Good afternoon, everyone, and thank you so much for joining us today. My name is Ana Maria Studer. I'm the Advocacy Support Program Manager here at Standpoint. This webinar is being recorded, and you will be able to check it out on Standpoint's YouTube page later on. The link to the recording will also be emailed out to Standpoint's Legal Advocate listserv. And for today's presentation, I'm going to put on the chat box the link for the PowerPoint if that's going to be easier and it's going to help to follow along. My role today is to help facilitate the webinar. If you have questions during the presentation, please type your question in the Q&A tab or the chat, and we'll pass the question along. Most of you probably already know about Standpoint, but for those that listen to this later or don't know about our organization, Standpoint is a statewide organization. We are a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to system professionals who work with survivors, and we do this by facilitating trainings and answering calls through our action line. Examples of the trainings that we give are the new laws training that we bring to the whole state on the summer months every year. We also do the monthly webinars for advocates like the one we're offering today, and other trainings by request. Our action line is answered Monday to Friday from 9 a.m. to 4 p.m. And it's going to be through that action line that our attorneys are going to provide legal advice, and our advocates are going to connect callers with resources. We do safety planning. We listen and help callers identify possible options and next steps. For today's webinar, Temporary Custody Options, our presenter is one of our staff attorney, Sammy Sexton. Sammy joined Standpoint in May of 2024. She is a graduate of New York University School of Law and has focused her legal work on helping victim survivors navigate the family court system. Prior to joining Standpoint, Sammy worked at Central Minnesota Legal Services, where she represents survivors of domestic violence in family court proceedings, including custody, divorce, and orders for protection. As a staff attorney at Standpoint, Sammy provides legal advice and consultation on family law issues affecting victim survivors. And it's with great pleasure that I introduce Sammy. All yours.
Thank you. And thank you all for coming to our webinar today. I'm just going to share my screen to put up a PowerPoint. Okay. So today, like Ana Maria mentioned, we'll be going over temporary custody options. And one thing I wanted to mention just from the start is that what we're covering today really applies when someone either doesn't have custody and they need to establish custody, or when there is some kind of custody order and they need to quickly modify it due to some kind of safety concern. We're not going to be covering enforcement of current custody orders or enforcement of an unmarried mother's statutory right to sole custody. We have had previous trainings on those topics. I'm sure we will have future trainings on those topics because they come up really frequently, but it's just not the focus of today's presentation. So, and as we go through the training, feel free to put questions in the chat or in the Q&A. I'm going to try to monitor them as best as I can. And we're also going to go over some examples and have a chance for you to put your thoughts about the examples in the chat. So please feel free to participate in the chat and make it a little more interactive. Okay, so getting started. A really common question that comes up when you're working with victim survivors is, my child is in danger. What can I do to protect them? And so for today's presentation, we'll be going over two main options for protecting children through establishing temporary custody. One is an order for protection, and one is to file a motion in a family court case, like a custody case or a divorce proceeding. And those two options are appropriate in different types of situations. So we're going to go over what each one requires and get into some examples to kind of illustrate the differences between them. So we're going to start with orders for protection. So most of you probably know at least the basics of an order for protection, but this is primarily a no contact order, but it can include other types of relief, including temporary custody of children and temporary child support. To file for an order for protection, there needs to be a showing that the petitioner or the children or both have experienced domestic abuse. And when you're thinking about how to protect children through an order for protection, there are two options. If the children have directly experienced domestic abuse, they can be included as protected parties on the order for protection. Or if they haven't experienced domestic abuse, but there's still safety concerns, the petitioner can ask for temporary custody. So just as a reminder for everyone of the domestic abuse definition, this is what we're thinking about having to prove when we are filing orders for protection. Domestic abuse has to be committed against a family or household member, and it includes physical harm, bodily injury, or assault, the infliction of fear of imminent physical harm, bodily injury, or assault, terroristic threats, which are also called threats of violence, criminal sexual conduct, sexual extortion, and interference with an emergency call. So when you're working with someone and you're thinking about whether they might qualify for an order for protection, these are the definitions you're going to need to be thinking about. And so a lot of times parents might have safety concerns about the other parent withholding parenting time from them or taking their child out of state without permission. And those are really concerning for parents. They often are very worried about their child's safety in those situations, but those are not included in the domestic abuse definition. So if those are the only issues that a parent is bringing up and there is not a history of domestic abuse, then it's not going to be worth it to try to address those issues through an order for protection because the order for protection isn't going to be granted and it's just going to be essentially wasting time filling out the paperwork and waiting for the court order that's just going to deny it anyway. Sometimes people do, I've seen people try to address those types of issues through orders for protection where the entire petition is just saying that the other parent has taken the child out of state and is refusing contact, refusing to allow the petitioner to contact the child. And those petitions, if that's all that's in the petition, there's no allegation that there's been any physical harm towards the petitioner or the child, no fear of imminent physical harm, no threats, nothing else that falls into this domestic abuse definition, then those petitions get denied because that's not what the order for protection is designed for. So if those are the concerns, then the option is to file a motion in family court, which we'll talk about in the second half of this presentation. But if there has been domestic abuse towards either the petitioner or the child, then an order for protection is an option. Another thing to keep in mind is that each person that you want to include as a protected party needs to have directly experienced domestic abuse. So a lot of parents want to include their children as a protected party if the child witnessed domestic abuse towards the parent. And I think we can all understand where that impulse is coming from because we know that children witnessing domestic abuse is emotionally harmful to them. But witnessing domestic abuse is not included in the definition of domestic abuse. So a child is not going to be able to be included as a protected party on the order for protection if the only allegation for the child is that they witnessed domestic abuse against someone else. But if there was domestic abuse committed against the child, then they can be included as a protected party. And if there are multiple children in the household, then there has to be a showing in the petition that each child who you want included as a protected party experienced domestic abuse. So sometimes I've seen petitions that describe domestic abuse in detail towards one child, but they're also trying to protect the child's two siblings. And if there aren't any allegations of domestic abuse towards the siblings, then the court's only going to issue that order for protection for the one child and not the two siblings. So if you want to include multiple children as protected parties, there has to be information in the petition about domestic abuse towards each individual child. One other thing to remember when we're thinking about orders for protection for children is the definition of a family or household member. It is possible for someone to be a family or household member of the petitioner, but not necessarily of the child. So a family or household member is someone that's related by blood, a parent, or someone who's living with the protected party, or someone who is in a significant romantic or sexual relationship with the protected party. So sometimes there might be a respondent in an order for protection who is in a significant romantic or sexual relationship with the petitioner, but they're not the biological parent of the petitioner's children, and they don't live with the petitioner. In that case, they are a family or household member of the petitioner, but not the children, because they don't have that blood relationship with the children and they're not living with them. And so the petitioner could get an order for protection in that case, but they aren't going to be able to file the order for protection on behalf of the children because the respondent isn't the children's family or household member. If the respondent is their parent or if they live with the children, then they are a family or household member. And so you could get an order for protection on behalf of the children if that person has committed domestic abuse against them. Okay, so just to illustrate some common scenarios that may be domestic abuse or may not be, I wanted to go over some examples. And for each example, if you guys just want to put in the chat whether you think someone could file an order for protection in this instance, and then we'll go over whether they actually could. So the first example, Amy's boyfriend, Paul, punched her and pushed her to the ground. Their 3-year-old child, David, was in the room. David began crying when Amy fell to the ground. Paul yelled at David to be quiet. David continued crying and hid in another room. Can Amy file for an order for protection on behalf of David? And for these examples, just assume Amy and Paul live together. So Paul is a family or household member of both Amy and David. And we know Amy could file for an order for protection on her own behalf because Paul punched her and pushed her. So the question is, could she also file on behalf of David? So hopefully a few people will put some thoughts in the chat. Okay, seeing a lot of no's popping up in the chat. And that is right. So David had pretty clearly an emotional reaction, but his concern seemed more to be for Amy's safety, not necessarily him being worried that Paul was going to physically harm him in that moment. And even though Paul yelled at him and caused further emotional harm isn't in the statutory definition of domestic abuse. So she's not going to be able to file for an order for protection on behalf of David. So next, we're going to change the scenario a little bit. So still Amy and Paul. This time, David was standing right next to Amy when Paul punched her and pushed her to the ground. And so when she fell, she accidentally landed partially on David, which resulted in a bruise to his leg. So in this scenario, can she file for an order for protection on behalf of David? Okay, a little bit more of a mix on this question. So a couple yeses and several nos. One person says, I think our judge would grant this. Yeah, so a little bit, this example is going to come down to judges. I think that legally, the answer is no. Even though David was harmed, Paul didn't have an intent to harm David. And so accidental injuries that are an indirect result of other acts of domestic abuse don't fall into that domestic abuse definition. But I think the point about individual judges is a good one because I have seen some district court judges who would grant a petition like this. The risk of that is that if something like that were granted and the respondent wanted to appeal, that order is vulnerable on appeal. So it is definitely possible that some district court judges would grant this, but if the respondent had the means and ability to appeal it, it could be overturned on appeal. Somebody asked what if she was holding David and Paul pushed Amy. That does come up a lot as well. And I think, again, it kind of comes down to individual judges. I think that one, I'm not sure if we've seen a Court of Appeals opinion with that fact pattern, so I can't say for sure what a Court of Appeals would do because I think that is more arguable that um, Paul might have intended to harm David as well, or that David might have been in fear of imminent harm to himself and not just to Amy. So that one I think probably a little bit more likely to be granted. I would definitely recommend, if that's the situation, putting in information in the petition about if the child seemed afraid that he was going to be hurt. And then someone asked if granted and appealed, would the entire order be overturned or would the child's inclusion as a protected party just be overturned? It would just be the child's inclusion, as long as there was still evidence in the record to support the OFP being granted for the adult. If that wasn't being challenged on appeal as well, then the order for protection would remain in place for Amy, but it could be vacated with respect to the child. Okay, so for the next example, again, Amy's boyfriend Paul punched her and pushed her to the ground. 3-year-old child David was in the room. David began crying. Paul picked David up, took him to the car, and drove away. The whole time Paul carried him to the car, David continued crying and asking to stay with Amy. So this time, can Amy file for an order for protection on behalf of David? I only see one response in the chat. Okay, 2 responses in the chat. So we've got one yes and okay, a couple more no's coming in. So yeah, this one again, and then somebody says maybe if David was in imminent fear, and we highlight that in the petition. So that's what I think this really does come down to. Based on just these facts, if these were the only facts in the petition, I think the answer is no. Because even though David was crying, that's not really sufficient to show that he was in fear for his own physical safety. He most likely started crying as a concern for Amy and continued crying because he wanted to stay with Amy and he's worried about her safety. There's not really enough in this set of facts to show that David was afraid for his own physical safety. If he did start saying something like, I don't want you to hurt me too, or saying that he's scared of Paul, that might be enough for some judges to grant this. I also think, again, some district court judges would grant an OFP on this fact pattern anyway, because some judges could be convinced that this is sufficient for domestic abuse, but those orders are going to be vulnerable on appeal as well because it doesn't actually meet the standard of showing that David feared for his physical safety. Okay, this time, we have another example. Paul picked David up, took him to the car, drove away. David continued crying and asking to stay with Amy. This time, Paul told David, "Shut up before I have to teach you a lesson like I did to your mom." On these facts, could Amy file for an order for protection on David's behalf? Yeah, seeing a lot of yeses in the chat. And that is correct. This time, Paul made a threat of violence towards David, which is in that definition of domestic abuse, so she could file for the order for protection on behalf of David. Okay, this is an example that comes up really frequently. So this time, Paul picked David up, took him to the car, drove away. Amy knew that Paul had been drinking all day and could not safely drive. Can she file for an order for protection on behalf of David? Okay, I saw a couple yeses in the chat. One, I don't think so. A few no's coming in. So the answer is no. Drunk driving with a child in the car, obviously a bad parenting decision. It does put the child in danger, but it doesn't meet the statutory definition of domestic abuse because the statute really draws this distinction between just irresponsible, neglectful actions versus intentional, violent actions. Somebody asked about fear of harm. I think that's hard in this situation because David's only 3. He probably doesn't know how dangerous it is to drink and drive. He might not even understand that Paul has been drinking all day. So I think it would be hard to prove that he was afraid for his safety based on the drinking. Again, if there were facts saying that he had made some kind of statement about being afraid of Paul or being afraid that Paul would hurt him, that might be sufficient to get an order for protection. But just the fact that Paul had been drinking and then drove with David in the car, I think it's going to be hard to prove that David feared for his safety based on that. Okay, we have one more example before our next section. So this time, Paul again picked David up, took him to the car, drove away. Amy texted Paul and asked him to bring David back home. Paul refused. Amy has not seen Paul or David now for 3 days. She's tried calling the police, but they told her that since she doesn't have a court order, they can't do anything. Can she file for an order for protection on behalf of David? Seeing several no's in the chat, which is correct. Paul's refusal to allow Amy to see David is not within the statutory definition of domestic abuse. It's probably emotional harm because we can presume David has a pretty strong bond with Amy and now he's suddenly being cut off from her. But emotional harm isn't in that statutory definition, so she's not going to be able to get the order for protection on behalf of David. That doesn't mean she's out of options for seeing David again, it just means she can't file an order for protection on his behalf. Okay, so next, if you can't file an order for protection on behalf of the child, can you still request temporary custody in the order for protection? As long as the petitioner has experienced domestic abuse, and so there's enough for a judge to grant the order for protection, the petitioner can request temporary custody, even if the child didn't directly experience domestic abuse. And the court is required to give primary consideration to the safety of the victim and the children. They can consider best interest factors. That would be the same list of best interest factors that are considered in every custody case. But unlike a custody case, the court is not required to make findings on every best interest factor. They can consider the ones that are most important in the order for protection context and primarily the ones that relate to safety. The court might also impose conditions on parenting time or restrict it as far as time, place, duration, supervision, or deny parenting time entirely. I saw one question pop up in the Q&A. So this is a good question. Somebody asked, I'm curious about your thoughts on a child's ability to be included as a protected party in an OFP if the domestic abuse perpetrated against the child happened while the child was in utero. For example, if respondent assaulted a pregnant petitioner with the expressed intent of ending petitioner's pregnancy against her will, and now baby has been born and petitioner wants an OFP protecting her and baby with the basis for including the child being the assault on mom while pregnant with the child. I think that's probably a bit of an open question in our law. I'm not aware of any Court of Appeals decision on it. I'm not going to say there isn't any appellate decision on it, but I'm not aware of any. And I can definitely see the argument for including the child on the order for protection for that. On the other hand, I think there's a lot of concerns about treating the implications of treating unborn children the same as people under the law and what else that might lead to in other areas of law. And so I don't think we have an appellate opinion that does that in Minnesota, at least in the order for protection context. I believe we have a criminal law about assaulting an unborn child, but that's very explicit in the criminal statute, that it can be included, and we don't have that explicitly in the order for protection statute. So I think it's a bit of an open question. Right now, it would probably be kind of up to the district court judges until an order gets appealed and we get some precedent on it. I would guess that a lot of district court judges would probably not include the child as a protected party in that case, because they would say the child wasn't born. At that point, it was an assault on the mother. But it would be a really strong case to ask for temporary custody in the order for protection if the petitioner needs to do that. So great question. I think kind of an open question that maybe the courts will resolve someday if a case comes up on appeal. So temporary custody, just because someone can request temporary custody in an order for protection doesn't necessarily mean that they should. So it all depends on their marital status and whether they have any prior court orders about custody. So if the petitioner and the respondent are married and there is no prior custody order, so they've never filed for divorce, they're pretty much presumed to share joint custody. So if the petitioner doesn't want to continue sharing joint custody with the respondent, they should request temporary custody of their child if they're filing an order for protection. If there is some kind of prior court order and it adequately protects the child's safety, maybe it already limits the respondent's parenting time, then there's probably also no need to request temporary custody. But if it doesn't adequately protect the child, then requesting temporary custody in the order for protection is essentially a way to temporarily modify that order to better protect the child's safety. If the petitioner is unmarried and she is the mother of the child and there's no prior court order, then she should not request temporary custody because she already has sole custody by statute. And one thing about requesting temporary custody in an order for protection is that it requires a hearing. So there's certain relief in orders for protection that can be issued without a hearing, and a hearing will only be held if the respondent requests one within 5 days of being served with the order for protection. And there's other types of relief that require a hearing, and so the court will automatically schedule one. Temporary custody requires a hearing. So if that's the only thing that someone is requesting that is going to trigger that automatic hearing, and they already have sole custody by statute because they're an unmarried mother, it is not worth triggering that automatic hearing to request something that she already has. Sometimes people want to know, well, the police have told me I need a court order, or else they can't enforce the fact that I have temporary custody. There are ways to ask for the court to include in an order for protection a statement that the mother has sole custody and direction for law enforcement to help enforce that. The better way to do it instead of requesting temporary custody in that situation is in the paragraph about where it asks if you want the order to direct local law enforcement to provide assistance. You can request that law enforcement be directed to assist petitioner in retrieving the child. There's also a paragraph labeled Other, where you can put other relief you're requesting, and so you can request that the order specifically state that the mother has sole custody. If there is a prior court order, then it depends on what that prior court order says. If the custody order already adequately protects the child's safety, then there's still no need to request temporary custody. But if the order needs to be changed to address safety, then requesting temporary custody is a way to do that. If the petitioner is an unmarried father and there's no current court order, then he would need to request temporary custody because in that situation, the mother has sole custody. Or if he needs to change a current court order to better protect the child, he can request temporary custody. One thing to know for fathers, though, is that if they haven't established paternity, so if there is no recognition of parentage signed, then the court can't grant them temporary custody in an order for protection, so they actually need to file a paternity case. If they have a recognition of parentage, the court can give them temporary custody and parenting time. But if they don't, then they need a paternity order. Okay, I just saw a question in the Q&A. I think it's what I just answered, but I'll just make sure. Someone asked, does the recognition of parentage change that for the father, or does it need to be a custody agreement? As long as there is a recognition of parentage, the father can be awarded temporary custody or parenting time in the order for protection. Okay, so we have some examples on this as well. So going back to Amy and Paul, um, Amy's boyfriend Paul punched her and pushed her to the ground. Her 3-year-old child David was in the room. David began crying. Paul picked David up, took him to the car, drove away. Amy texted Paul and asked him to bring David back home. Paul refused. Now Amy hasn't seen them for 3 days. Again, she tried calling the police, but they told her that since she doesn't have a court order, they can't do anything. So you have 2 questions for this example. The first is, can Amy file for an order for protection for herself and request temporary custody of David? And the second question is, should she do that? So you can put some thoughts in the chat about that. Okay, so it seems there's mostly agreement on the first question that she can file for an order for protection for herself, um, which is right. Paul did commit domestic abuse against her when he punched her and pushed her to the ground, so she qualifies for an order for protection. And the fact that Paul exposed David to domestic abuse and then refused to let him have contact with Amy can be considered as reasons to grant custody to Amy. However, when it comes to should she request temporary custody, she should not, because she and Paul are not married. And so and there's no current court order. So she already has sole custody. And so asking for temporary custody triggers an automatic hearing, which she might not want to do. And so instead, she can ask for the OFP to state that she has sole custody and that Paul must return David to her care. The couple questions came up in the chat. Could the OFP be filed on only her, but then other requests be to return the child? Yes. That's exactly what I would recommend in that scenario. And then someone else asked, what about when law enforcement refuses to remove the child from the father because it's a family issue? That's why you want to ask for the OFP to specifically say that Amy has sole custody and that law enforcement needs to assist her in getting David back from Paul. Usually, once there's a court order, law enforcement is a little more willing to help. I know it's still not perfect. Sometimes they'll still say, we're not gonna take a child out of his father's arms. And in that case, then I think the option becomes potentially filing for a modification of the OFP to ask for even stronger language for law enforcement or filing a contempt motion. But in a lot of cases, getting it into the order for protection is going to help law enforcement be more willing to enforce it. And there was one question in the Q&A. Someone said, we've always heard that unmarried mothers with sole custody should avoid even petitioning for an OFP on behalf of their joint children as protected parties because it would open the door for father to ask for custody or parenting time to be ordered and the court to actually order it through the order for protection. Is this accurate? So I would say it's partially accurate, but I don't think it doesn't depend on whether the children are included as protected parties. A respondent can, if it's a respondent who has some form of paternity established, so either he's married to the children's mother or he has a recognition of parentage or a paternity order, a respondent can ask for custody or parenting time to be ordered in the OFP, and he can do that even if the children are not listed as protected parties. So even if Amy, in this example, Amy only files an OFP on her own behalf, and even if she didn't ask for sole custody of David and she didn't list David as a protected party, Paul could still request a hearing and then go to that hearing and say, Your Honor, I want temporary custody of David. I want a temporary parenting time schedule. I think on these facts, it's unlikely that Paul would get temporary custody, but the court could issue a temporary parenting time schedule based on Paul's request. So that is something to discuss with petitioners, because even if the petitioner is not requesting temporary custody or parenting time and not filing on behalf of the children, the respondent can make that request at a hearing. The court can grant it. Some judges won't. Some judges will just say, I think that's an issue for family court. We're not going to do it in the order for protection. But some judges will, if they think that this is just that not having an order is going to lead to more conflict between the parents. Some judges will do a temporary order. So that is basically always a risk of orders for protection, is that the father could ask for temporary parenting time. Okay, we've got another example with Amy and Paul. So in this case, same facts. Paul took David. Amy hasn't seen Paul or David for 3 days, but in this scenario, they do have a prior custody order. They have joint physical custody and equal parenting time on a 2-2-3 schedule, but Paul is now refusing to follow that. She's tried calling the police. They told her it's a civil matter and she should contact the court. So now, can she file for an order for protection for herself and request temporary custody of David, and should she? Okay, seeing some yeses to both questions coming in the chat, which is correct. She can file for an order for protection and request temporary custody for the same reasons that we already talked about. And because she needs to change a prior custody order, she should request temporary custody of David and ask for specific language in the OFP directing law enforcement to assist with returning David to her care. Okay, so that's orders for protection and temporary custody. We're going to move on to requesting temporary custody in family court. I'm going to give it a minute just in case anybody has more questions on orders for protection first. So if you have a question, feel free to put it in the chat or in the Q&A. Okay, not seeing anything pop up. If you think of anything later, still feel free to put it in the chat or Q&A. I just wanted to make sure if there were any immediate questions to address those before we move on. So now we'll talk about other temporary custody options. So maybe if somebody doesn't qualify for an order for protection, maybe there wasn't domestic abuse, but there's still other safety concerns, or maybe they just don't want to file for an order for protection. If they're filing in family court, the family court must consider all best interest factors. And so that's a lot broader than what the court can consider when they're thinking about whether to issue an order for protection. So the family court can consider neglectful actions, substance use, reckless driving with a child in the car, exposing the child to domestic abuse, failing to obtain necessary medical care for a child, all things that are safety issues, but would not meet the domestic abuse definition. There are a few options to file in family court. there is a motion called a motion for parenting time assistance, which is a good way to change a parenting time schedule or change exchange locations, things like that. And to change a parenting time schedule, you have to show that there has been some change in circumstances since the prior order was issued, and that the change that you're requesting is in the children's best interests. And if you are requesting a restriction in the other parent's parenting time, so maybe you're asking for them to get substantially less time than the prior order gave them, or you're asking for their visits to be supervised, then there has to be a showing that the child is endangered in their care. And that can be physical or emotional endangerment. The other option is a custody modification motion. And that's if you need to change, in addition maybe to changing parenting time, you need to change the physical and legal custody labels. And so for that, you again have to show there's been a change in circumstances and that the proposed change is in the children's best interests. And you have to show either endangerment or integration. So endangerment, the way the statute defines that is that the child's present environment endangers their physical or emotional health or impairs their emotional development, and the harm likely to be caused by a change of environment is outweighed by the advantage of the change to the child. So basically, they are in such danger in whatever the current environment is that even the emotional harm that might be caused by uprooting that arrangement, that's outweighed by the advantage that this change is going to make. And when you're thinking about the child's present environment, that refers to the last judicially created environment. So that's whatever the previous order says. So sometimes people aren't necessarily following the court order because maybe they've reached some other kind of informal agreement, but the court, when they're looking at the present environment for the purposes of determining whether the child is endangered, they're looking at what the most recent court order establishes. And for integration, what that means is that the child has been integrated into the family of the petitioner with the consent of the other party. So that might happen where maybe there's a parenting time schedule and then one parent just stops using their parenting time for some reason, and they don't really try to contact the child or change the schedule. They just really stop seeing them for a significant period of time. That would be considered integration. The consent to integration does not need to be explicit. You can imply it based on the other parent's actions. Usually, if you're asking for a custody modification based on integration into the parent's home, that's not going to be something that you could file an emergency motion for, because the court's going to look at that and say, well, it doesn't look like the child's in any danger if they're in your home anyway, and the other parent isn't trying to use parenting time. If you're arguing for a custody modification based on endangerment, depending on the situation, there might be a basis to ask for some emergency relief. And that's usually the next thing that comes up when people are thinking about filing motions, is they're thinking about the fact that usually when you file a motion, you have to serve it on the other party 21 days before a motion hearing can be held. But what if this is an immediate safety concern where you can't wait 21 days or longer? Because sometimes the court calendar is really full and you're not getting a motion hearing 21 days from now. You're getting one 2 months from now. And so in some circumstances, you can't wait 2 months for a motion hearing. And there are options to request faster relief from the court, but there is a pretty high bar to requesting that. One option is just to request that the court hold what's called an accelerated hearing, which is where the court can waive that usual 21-day service requirement and hold a hearing sooner. Another option is an emergency motion, where the court is still going to hold a faster hearing, but they actually are able to rule on your motion temporarily before a hearing. So if there's an immediate need for a court order, they can actually issue a temporary order, maybe suspending someone's parenting time, maybe transferring custody to the protective parent before a hearing even happens. And then they're going to hold a hearing pretty soon after that. One step above that is an ex parte motion, where the court is ruling on the motion before it's even served on the other party. So the difference between emergency and ex parte is that in an emergency motion, you're filing the motion at the same time that you are serving it on the other party. So they're getting notice that you are filing this motion before a court order is issued. If you're asking for an ex parte motion, you're basically saying there's some safety reason why I cannot serve this motion until there is a court order in place. And for that, you have to show that there is some kind of risk of maybe retaliation, harm to the child, if this other parent is notified. It's a really high bar. A lot of times there might be something that qualifies as an emergency, but does not qualify for an ex parte motion. And it is important to think about that distinction because if you file your motion ex parte and you're asking for an order before it is served and the judge disagrees, some judges will just tell you, go serve this, give me proof of service, and then I'll issue an emergency order. Some judges will just deny it and say this doesn't meet the requirements of an ex parte motion, denied. And then you have to file a whole new emergency motion and refile everything. And so it can cause a delay if you try to file for an ex parte motion when the situation does not meet the standard of an ex parte motion. And any kind of emergency that you're arguing to the court justifies this type of relief, there is a requirement that it was not caused by lack of diligence on the part of the moving party. So that means that once the situation becomes an emergency, if the parent who wants to file the motion waits too long, then the court's going to say, well, this is no longer an emergency. So sometimes I've seen this happen where one parent is maybe withholding parenting time. And for some reason, the custodial parent, maybe they don't know what their options are. They don't realize they can file an emergency motion. They don't file a motion for 3 months. And then they're saying, well, it's been 3 months and I haven't seen my child. And the court says, well, if this has been going on for 3 months, then it's not an emergency. So here's a motion hearing date 30 days from now. So that's just important to keep in mind that if you're looking at filing an emergency motion, you do need to act quickly to show the court that this actually is an emergency. It's something that you're treating as an emergency. One other option that I wanted to flag that'll be available sometimes, but not every time, is there is a new statute that just went into effect August 1st of this year that while a proceeding is pending, if a parent has been denied parenting time for at least 14 days and they file a motion asking for an expedited hearing, the court is required to hold that hearing within 30 days. But since the statute says, well, the proceeding is pending, that means if you're thinking maybe it needs to be a modification motion where there's already a final order and you need to reopen the case and modify the final order, that proceeding isn't pending at that point. So this probably isn't going to apply to that. But if there is an open case where maybe someone filed for custody, but there's no final order yet, the case is still open, there's mediation scheduled or some other kind of hearing scheduled, and now a parent is withholding parenting time, that's an option, is to request this expedited hearing. So I know that this is a lot of information. These situations are really complicated and it can be hard to tell what is an emergency and what might be ex parte. So I do have a few examples just to kind of illustrate these kinds of situations. But first, I just wanted to list some specific rules that apply to these motions. So you can find the rules about emergency and ex parte motions in the General Rules of Practice 303.04, and it lists out all the special things that you need to include. You have to state why emergency relief is necessary, specifically what relief you're requesting. And you have to disclose any other attempts to obtain the same or similar relief and the result, including the name of the judicial officer that the relief was requested from, and what new facts are presented to support the current motion. And you have to include a proposed order. That sometimes trips people up on these motions because for most motions, you only need a notice of motion and then an affidavit explaining why you're asking for what you're asking for. But the rules for these motions specifically say that you also need to file a proposed order, which is basically the order that you would want the judge to sign. And so it's just a blank order that says, it lists whatever relief you're requesting, and then it's got like a blank spot where the judge could sign it. If they just agree with everything you're asking for, they can just quickly sign that. If they don't agree with everything you're asking for, they'll edit your proposed order to whatever they want it to say. But they do require that you include one. And if you're requesting ex parte relief where you're not serving the other party, you have to show good cause why notice to the other party should not be required. So for our first example, Jessica and her boyfriend Alex broke up 2 years ago. They have one child together, a 5-year-old named Michelle. Alex filed for custody last year, and their final custody order gives him parenting time every other weekend from Friday at 6 p.m. until Sunday at 6 p.m. Jessica just found out that Alex was arrested for drunk driving during his most recent weekend of parenting time. Michelle was not in the car, but she'd been left home alone. Jessica told Alex that she isn't comfortable with Michelle returning for parenting time next weekend, but Alex told her she has to follow the court order and threatened to call the police if she doesn't show up to the scheduled exchange. What can Jessica do? So if you have a guess, go ahead and put it in the chat, and then we'll go over what her options are. Okay, seen one person say emergency. And that is right. She can file an emergency motion asking to suspend Alex's parenting time. And the reason she can file it as an emergency motion is because there's really limited time until Alex's next scheduled parenting time, so she can't wait out that normal 21-day motion timeline. And there is an immediate risk that Alex's drinking poses to Michelle because now she knows Alex was drinking during his parenting time and he left Michelle home alone. She's only 5. That's not responsible parenting behavior. And so it does qualify as an emergency. I did want to note this probably could not be filed ex parte. So it can be filed as an emergency, but she's going to have to serve Alex with the motion papers when she files them. Because Alex already knows that Jessica wants to suspend his parenting time, and Michelle isn't currently in his care, so there's not really a risk of him trying to withhold Michelle. And so unless he's made some kind of threat to harm Jessica if she goes to court, she is going to need to go ahead and serve that motion when she files it. Okay, so for the next example, Stacy and her boyfriend, Charles, broke up 2 years ago. They share joint legal custody and joint physical custody of their 10-year-old son, Oliver, and they have a 5-2-2-5 parenting time schedule. They are each granted a 2-week period of vacation during the summer. Stacy was scheduled to have vacation time from June 1st through 15th. Charles has recently gotten into a fringe political ideology and considers himself a sovereign citizen. He says that U.S. courts have no authority over him. During Stacy's vacation time, Charles posted on Facebook that Stacy had kidnapped Oliver and that he would go to Stacy's vacation location to get him back. Charles said that no one could keep him from his son and that even the police could not stop him from seeing Oliver. He said that as soon as Oliver was back in his care, he would take him to another state so that Stacy could never find him again. So if you want to put your ideas in the chat, what do you think Stacy could do? Could she file an emergency motion in this scenario? Could she maybe file an ex parte motion? And put your thoughts on that in the chat. All right. I see several people saying emergency order, a few people saying ex parte. So yeah, she can file this ex parte and ask to suspend Charles's parenting time. The reason it's an emergency is because there are less than 2 weeks until Charles's parenting time is scheduled to begin. So this needs to be addressed because of the very real risk that Charles will withhold the child once he has parenting time again. And the reason it can be filed ex parte is because he threatened to show up at Stacy's location to take Oliver from her and stated he believes she kidnapped Oliver. And so that makes the likelihood of retaliation pretty high if he finds out in advance that she's filing a motion trying to suspend his parenting time when he's already saying that she kidnapped him and he knows where she is and has threatened to show up there. The risk of retaliation is high enough that I think most judges would allow this to be filed ex parte. I did want to note Charles will still find out about the motion after the ex parte order is granted. The order is going to include a requirement for Stacy to serve Charles with the motion paperwork, and then there's going to be a hearing scheduled. So just because it can be filed ex parte doesn't mean Charles never finds out that Stacy filed. It just means he won't find out until after she gets an order suspending his parenting time. And so it is going to be important in a situation like this for her to work with an advocate on safety planning and be prepared to file an order for protection if Charles makes threats towards her, or maybe a harassment restraining order if he's not making threats of violence but is harassing her. Okay, and then we just have one more example. Owen has parenting time with his 8-year-old son Josh on Wednesday evenings and every other weekend. After the most recent weekend of parenting time, Josh returned home crying. His mother, Chelsea, asked him what was wrong, and all Josh would tell her was, "Daddy was mean to me." On Monday, Josh started crying again and asked if he could skip parenting time on Wednesday. He said that he was scared to go back to Owen's house. He disclosed that Owen had hit him when he took too long to clean his room. Chelsea told Owen that Josh would not be attending parenting time on Wednesday and that she was concerned about Josh's safety. Owen replied, "It's my time. You have to follow the court order. There are no safety issues at my house. You're the one that tells him to hate me." So what options does Chelsea have? Okay, seeing a couple of people say an ex parte order. I don't think this would actually meet the requirements for an ex parte order, but she could file an emergency motion. It does qualify as an emergency because Josh is in immediate danger in Owen's care. There's only 2 days until Owen's parenting time begins again. But right now, Josh is in Chelsea's care. And so there's not, when she files her motion on Monday with Josh in her care, there's not a risk of him retaliating against Josh for disclosing the abuse because he's not with Josh. And there hasn't been, there's nothing in the fact pattern saying that he threatened to retaliate against Chelsea if she files a motion. So I think most judges would probably not consider this an ex parte situation, but it is an emergency. The other option is she could file for an order for protection on Josh's behalf. So this is a scenario where she has the choice to either go to family court or file an order for protection because the fact that that Owen hit Josh is domestic abuse, and so she could get an order for protection. Okay, so I know that was probably a lot of information, and these are really complicated situations in a lot of cases. They are often very fact specific about what you can file and whether you might be able to file it as an emergency or ex parte or an OFP. So I wanted to, make sure to put Standpoint's contact information up here because you can always call our action line if you're working with someone and you're not totally sure maybe if this meets the requirements to file it as an ex parte motion, or if you aren't sure what paperwork to file or what type of motion, or you're debating between filing a family court motion or an order for protection, you can always call our action line. We are happy to talk through those issues with you. I've also put my contact information up here, so if you have questions about this presentation later, you can reach out to me. But if anyone has questions now, I'm happy to stay on and answer them. And I do see one in the Q&A. Does custody and parenting time ordered through an OFP trump any existing or previously ordered custody order? Generally, yes. It's usually whatever the most recent order is what's going to control. So if you have a custody order in place and then there's an OFP that issues a temporary custody order and changes that, then the OFP is going to control. But then if somebody goes back to family court and files a motion to modify that previous custody order and they say, maybe the judge says, yeah, I see this OFP, but I'm going to modify it actually to something different than what the OFP says, then that more recent family court order is what's going to control. So in most cases, it's whatever the most recent order is. The only exception is if you get a temporary custody or parenting time order in an OFP, and then the OFP expires. The temporary custody and parenting time order also expires. That's why it's called temporary custody and parenting time, because it's only in place while the OFP is. So if there's a prior order, then there's an OFP for 2 years with a temporary parenting time schedule, and then the OFP expires, it's going to go back to whatever was in that prior order. So sometimes, if you want the modifications to be permanent, you have to do both, where maybe you file the order for protection to address the immediate safety concerns and get an immediate change to that order, but then you might still need to file a motion to modify parenting time in the family court case to make sure that it's a more permanent order and that you're still going to have the modification after the OFP expires. Somebody asked about doing these without an attorney. It really depends on how complicated the facts are. Emergency and ex parte motions, I think, are harder to do without an attorney. Not impossible, but more difficult. Partially because the courts make it harder to find the forms for those kinds of motions. They are not available on the court's website. Usually, if you call the self-help center or the law library, they will give someone the forms, but not always. I've had a couple times where I've advised people to contact the self-help center, and then I get a call back and they say the self-help center won't give me these forms. So getting the forms can be a challenge for someone who doesn't have an attorney. And then because there are those very specific procedural requirements for emergency and ex parte orders, I think that can be challenging for someone without an attorney to just make sure that they're hitting all of those procedural requirements. So I think it requires a little more guidance usually. And I usually, if I'm advising someone who is wanting to file an emergency motion, I do make sure to go through all of those procedural requirements with them. So it's doable without an attorney. I think it's like most other family law issues where you can certainly do it without an attorney. It's probably easier with one, but we all know that not everyone has the resources to get an attorney. So I think it is possible for someone to do it on their own if they have the right information. Looks like there's a follow-up question in the chat. Are they willing to give the forms to advocacy organizations? I'm not sure, but Standpoint does have sample emergency and ex parte motion forms. So generally, I would say have clients check with the self-help center first, because some counties might have preferred forms for those counties. But if you're having trouble with the self-help center, you can reach out to Standpoint. We can provide generic emergency motion forms if you're not getting them elsewhere. Okay, I see a question in the Q&A. There's a situation where mom and dad share custody, but CPS got involved and developed a safety plan so that dad can't have contact with the child at this time. Is it beneficial for mom to do both an OFP on behalf of the child and an emergency custody order? I mean, she could do, I think she should pick one to do on the emergency basis. Because if she gets the OFP, then the custody modification isn't as much of an emergency if she gets temporary custody granted in the OFP. So I don't think you need to do both on an emergency basis. But if you modify custody through the OFP and you want it to be a permanent modification, then there should be a modification motion in the family court case at some point. It's just not quite as time sensitive once you have kind of the immediate modification through the order for protection. But that is a good point to bring up about CPS. Sometimes CPS will develop safety plans and they'll say, here's what we think context should be. CPS doesn't have the ability to modify court orders. So even if you're working with CPS and they're developing a safety plan, it is often still important to file something, whether it's the order for protection or an emergency custody motion. Okay, that's all the questions I see for now. I'll wait a couple extra minutes in case someone has more that you want to ask. But otherwise, thank you all for coming to our webinar. And if you think of questions later, feel free to reach out either on our action line or you can email me.
Thank you so much, Sammy, for doing this webinar. It was great. Thank you, Raylene, for being behind the scenes and helping me. And thank you, everybody, for being here today. And we'll see you again next month. Have a great day.